Ashraf al-Mursaleen. We are going to resume and go back to commercial law for business students for Al-Isra University students, and started on page 197 with the title Forming the Company. Forming the Company on page 197. A company is formed by one or more persons signing a memorandum of association and complying with the registration process as practiced as prescribed by the law. Note that it is possible for a company to consist of one member, which helps small businesses to register. The Memorandum of Association. The purpose of the memorandum is to state the intention of the subscribers to form a company and to become members of it. If the company is limited by shares, it must specify that they each hold at least one share. It used to contain some information which is now to be found in the company's articles of association. The memorandum no longer forms part of the company's constitution and has been regulated to being merely a historic document indicating who set the company up. It cannot be amended after registration. The registration process. The following documents must be delivered to the company's registry with the appropriate fee. Number 1, the Memorandum of Association. Number 2, the application of a registration, which includes A, the company's name, B, the company's domicile, C, the address of the company's registered office, D, the articles of association, E, whether the company is limited or unlimited, F, if limited, whether this is by shares guarantee, G, a share statement if the company is limited by shares indicating the amount of shares capital, how it is to be divided and initial shareholdings, H, the terms of any guarantee, I, names and addresses of the proposed officers, directors, company secretary, J, a statement of compliance with the registration procedure. The effect of registration. Excuse me. The registrar will register the company and issue the certificate of incorporation, provided that the legal formalities have been complied with and the company is intended to pursue a legal object. This makes the subscribers to the memorandum members of it, and the named officers are deemed to be appointed. The company is now legally capable of exercising its functions stated in the Constitution. The Company Constitution. The Articles of Association. Both the Memorandum of Association and the Articles of Associations contained different aspects of the company's constitution. The memorandum contained matters governing the relationship of the company to the outside world, while the articles purely concerned with the rules governing the internal management of the company. The articles include the information previously found in the memorandum. Contents of the articles: the company name, registered office, The objects of the company: rules governing internal conduct of the company's business. They will include, for example, the number of directors, the method of their appointment, powers of directors, means authorities of directors, the procedures for calling and conduct of meetings, voting rights of members, keeping of accounts, the payment of individuals. The company may therefore empower itself within the uh, confines of the law. The company's law prohibits some activities to permit others subject to compliance with certain procedures, such as altering the articles. Let us now look at the contents of the articles in more details. First of all, the company's name. The registrar will refuse to register a name if its use would constitute an offense or if it is offensive. For example, Pirated Limited will be rejected, or Pirates Limited Ltd will be rejected. The chosen name must not be the same as an existing company. Some names can be used only with permission from the ministry. These include any which suggest a connection with a government department or local authority. Where a company has limited liability, this must be made evident by placing PLC after the name of a public company and Ltd after the name of private company. The objects clause. Historically, the law required a precise statement of the objects to be pursued by the company, including the owners relevant to the fulfillment of the objects and specifying related transactions which the company might enter into. A contract exceeding the company's objects were totally void because it was ultra-virus. As time went on, the courts adopted a more flexible approach, provided that the new enterprise was capable of being linked to the main processes of the company. An objects clause might state that the object of the company is carry on business as a general commercial company, unless a company's article specifically restrict the objects of the company. Its objects are unrestricted. Any change to the objects must be reported to the company's registrar. The articles of the company represent contractual terms. The company's constitution acts as a binding contract between the company and its members. It is as if the company and each of its members had promised to observe its provisions. Any money payable by member is a debt due from the member to the company. Failure by one of the parties to carry out its obligations under the Constitution is accountable as a breach of contract by the company. The parties are bound by these terms, though the company is in the stronger position since it makes the rules and has the power to initiate their alteration. A personal action by the by one member against another is possible. Members' capacity to sue on the terms imposed by the Constitution is limited to enforcing their right as members. The fact that a breach of the Articles results in damage to them in their personal capacity does not allow them to sue for that breach. The Articles may, however, provide evidence of terms to be implied in a separate contract giving rise to personal rights. For example, this enables directors to sue for remuneration owed to them under the terms of the Articles. They must sue on the contract which appoints them, but its terms may be clarified by reference to Articles if necessary.